so I'll ask the CEO to record. There we go. And I will declare the General Council meeting of April 11th now open for business. Is there any declaration of pecuniary interest for the councillors this evening?
No.
Okay, since there's none, we'll move on into delegations. Number 3A, Agnew Lake Property Group representatives Ivan Chaumont, Leighton Roslin, and Glenn Tunnock to speak to council regarding the appeals received to the zoning bylaw amendment number 2021-34. I don't know who's going to start speaking this evening, but I'll turn it over to you guys.
Okay, I'll start off. First of all, I want to thank you, Mr. Mayor. I want to thank the council and Belinda for giving us the opportunity to be here tonight. With me tonight, I have our attorney, Mr. Leighton Roslin, and I have our planner, Mr. Glenn Tunnock, who I believe most of you know here as well. I also have some of the executive of the Agnew Lake Property Group here in attendance, and some members of the Agnew Lake Property Group as well. So with that, I think I'll pass it on to you, Glenn, if you want to take it from here.
Okay, thank you very much, Ivan. Can members of council hear me okay?
Yes.
Okay, that's important. I also want to thank council for the opportunity to meet with you. I can see the room. It looks like old home week for me. Been there many times, as you know, as your former planner. I want to thank council, and I also want to thank staff for their diligent effort in providing us with information and support over the last number of years. This process has been ongoing for about 5 years, as I think most of council know. I just want to briefly recap the planning process that has occurred. We prepared a draft plan of subdivision for the Agnew Lake waterfront area, and that was approved by council. So the plan of subdivision was approved under the Planning Act. And then as a partner, if you wish, to the approval of the plan of subdivision, there was a requirement to put zoning in place. And it was an update really to the existing zoning bylaw that's in place. But in any case, council approved bylaw 2020-25, and that was the zoning for that particular subdivision that set out the permitted uses and the requirements for development, as the case may be, set out lot areas and things of that nature. And I want to emphasize that that particular bylaw was not appealed. And as such, then there were no challenges on the roads, access to the roads, no challenges on the permitted uses, no challenges on the lot areas. So subsequent to that, the final subdivision was prepared. So this is the draft or the version that would be registered on title that was prepared by D.S. Dorland out of Sudbury. And as a consequence of that particular finalization, if you wish, of the lot areas and so forth, there were some differences between the lot areas that were shown in bylaw 2020. And that triggered the requirement for a zoning bylaw amendment. There were no changes to the permitted uses, no changes to the access to roads and so forth. There were some minor changes to the lot areas. And that was reflected in bylaw 2021-34, the bylaw that has been appealed. And bylaw 2021-34, all it does is replace the two tables with the lot areas. And so the lot areas were updated. So as a consequence of council adopting that particular document, there were 3 appeals that were filed by appellants in the area of the subdivision. So there are 2 property owners that have lots in the subdivision, and there was 1 property owner that has a lot outside of the subdivision. The appeals that were filed were not related to the matters in the bylaw amendment. So what I'm saying is that nobody dealt or addressed the issue of lot areas, which was the changes made to the bylaw. And in my opinion, when somebody appeals a bylaw, they must deal with the issues that are dealt with in the bylaw. So the appeal, for example, by Sylvia Burden and the appeal by Ed and Pat Wyris dealt with road access. Well, that was not an issue that was addressed in bylaw 2021-34. And they were concerned about reserving access to roads so that they would have obviously access to their lots. Ron Duffy's appeal was also related to access, not to lot area. In fact, lot area is a non-issue on his property because his property is outside of the registered plan of subdivision that we're talking about. So again, he was dealing with a matter that was not addressed in that particular bylaw amendment. So the issue then that was raised was, well, what do we do with the appeals? And under the Ontario Land Tribunal Rules of Procedure, a municipality can ask for a motion of dismissal where the appeals are not considered to be valid. They don't have planning merit. They may be considered vexatious and for the purpose of delay. So it's been suggested that that's the route to go, is to present a motion to the Ontario Land Tribunal arguing that the appeals should be dismissed because they don't relate to bylaw 2021-34. And they don't certainly have any planning merit in that respect. So that decision has not been made as a final decision by council, as I understand it. And there's certainly options in moving forward at this particular point in time. So the option typically is for the municipality to defend its bylaw. You know, we've made a lot of contributions and assisted council over the years with, as I say, the preparation of the draft plan of subdivision, the preparation of the bylaw, the preparation of the subdivision agreement. So those are recommendations, but ultimately it's council that makes the decision on any of those planning documents. So here's a case where council is faced with the decision of whether they defend their decision before the Ontario Land Tribunal. And it's my understanding that a report was prepared by the CAO, which you will consider tonight on that particular issue. Now, we recognize, as I'm sure council does, that there's a cost. And it can be a significant cost depending on the amount of time that's required for the hearing, the number of expert witnesses that might be involved, such as a land use planner. It could be somebody else, it could be a land surveyor. And so those are really unknowns. And it can be unfortunate that the burden of the costs lie on the municipality and perhaps not the applicant, the appellant, where the appellant is not represented by a solicitor or by an expert witness. And this is one of the unfortunate realities in parts of Ontario where you do get these kinds of appeals. And so there's a cost to the municipality. But it boils down to the question of, does the municipality want to defend its own bylaw? And there's the optics of that, because if they choose not to defend the bylaw, what's the impression that leaves with the members of the public, the members of their own municipality? And certainly it's a bylaw that's going to be in place for some time. So it's not just a case of what happens now. It was once the bylaw is in place, council will be responsible for administering that bylaw and for enforcing it if necessary. So it is, as I say, a council bylaw. Now, the Agnew Lake Property Association do recognize that they are a partner in this process. And that partnership has been a cooperative partnership, a collaborative partnership over the last number of years. We've worked together as a team, if you want to put it that way. We've worked for each other. And the association would like to carry forward with that. So the association is prepared, as I understand it, to help the municipality with the costs of defending the bylaw, if that's council's decision. And as I say, I think it's the preferred way to go because it is your bylaw. It's not the association, it's not the Agnew Lake Property Group's bylaw, it's your bylaw. I'm not in a position to speak for Agnew Lake in terms of the actual dollar values and so forth that might be involved. It's really up to them, but the message I want to convey to you, Mr. Mayor, and members of council is that the Agnew Lake Property Group are willing to help the municipality with the costs in view of this being a collaborative and cooperative process that we have been involved with for the last number of years. Now, just as a note on my experience with formerly the Ontario Municipal Board, now the Ontario Land Tribunal, the OLT. Typically, when you have a notice of motion for dismissal, it's up to the solicitor to argue that motion. And that may be done with or without an expert witness, depending on the circumstance. Often an expert witness will prepare an affidavit. The affidavit is used by the solicitor as part of the submission to the Ontario Land Tribunal. And the motion may be argued, and the appellants would have an opportunity to respond to whatever the motion is, or the argument is. And then it's left essentially to the Ontario Land Tribunal adjudicator to decide whether the motion for dismissal is valid or it's not. And if it's considered valid, then the hearing is dismissed, or the appeal is dismissed, and things are done. The bylaw will come into force. If the adjudicator feels that there should not be a motion of dismissal, in other words, he feels there's certain planning evidence that should be considered, then he will allow the hearing to proceed. What is unknown, Mr. Mayor and members of council, is first off, whether the appellants would be represented or not at the hearing. And that has certain implications for how the hearing is dealt with, because you are dealing with lay people that don't have the experience in making arguments or knowing what the process is. And often the tribunal will lean over backwards to try and assist them with the understanding of the process. But ultimately, if they don't have an expert witness, then the weight of their argument is much less than if an expert witness does provide evidence. So the unknown is whether the appellants will be represented or not. It's unknown whether a hearing would follow immediately upon the dismissal of the motion for dismissal. So if the township solicitor, for example, argues the motion and it's dismissed, then the hearing might proceed immediately. I don't know, because it may be a case where people feel they need more time to proceed, even though the tribunal has made it abundantly clear that everybody should be prepared to move forward as of when the hearing is scheduled. And the final unknown at this particular point is whether the hearing can be held virtually. There's a major advantage cost-wise to having it held virtually. It means that whoever is involved in the hearing doesn't have to come to the township office, and because typically a hearing would be in the township office with all the parties involved in the hearing present for the hearing. So we don't know whether the hearing will be held virtually or whether the Ontario Land Tribunal will choose to have the hearing in the room that you're in at this particular point in time. So again, just in summary, we want to thank you for your assistance and the cooperation and collaboration that have occurred over the last number of years. But we want to point out that it is certainly your decision as a council on whether you want to defend the bylaw or not. And the Agnew Lake Property Group is certainly prepared to share the cost of assisting you in that task. Thank you very much, Mr. Mayor.
All right, thank you, Mr. Tunnock. I'll go now. I think Mr. Roslin has his hand up, so I'll pass it over to you.
Thank you, Mr. Mayor. I think Glenn's done an excellent job in making the case for you to have you appreciate the issues that are needing to be decided. I just want to add a few things to what he said. An important thing to remember here is that, as Glenn has emphasized, it is your bylaw that is being attacked, and the Agnew Lake Property Group actually doesn't have standing in the proceedings as they are currently constituted to address the issues, because they're not a party to the appeal. The parties to the appeal are the township, the municipality, and the appellant, the three individuals that Glenn has named. Agnew Lake Property Group can apply to the tribunal to be named as a party. And then if they are named as a party, they can have carriage of whatever motions or whatever that they want to bring before the tribunal. And the proposal is that we're canvassing is that they would do exactly that. They would bring a motion to be made a party, and then a motion to have the appeals dismissed as frivolous and vexatious for the reasons that Glenn has outlined. I do need to be a bit careful here, and I want to state it on the record. I'm aware that the township has retained the law firm of Weaver Simmons, and in particular Natalie Schreier of Weaver Simmons, to represent the township's issues with respect to negotiating the subdivision agreement. And we have rules with the Law Society that I, as a lawyer, am not supposed to be making a pitch to you directly because you're represented by counsel, by counsel rather, legal counsel. So I don't want to go too far into the arguments that might be made at the tribunal. I just want to emphasize that there's a process that we, as on behalf of on behalf of the Agnew Lake Property Group, need to take in terms of asking for party status and then asking at the same time for dismissal of the appeals. Now, Glenn has already drafted an affidavit for use on that motion, on the two motions. And so from the point of view of expense, a lot of that expense that would need to be incurred has already been incurred by the Agnew Lake Property Group as a measure of good faith to demonstrate that they are serious about sharing responsibility for carriage of the matter before the tribunal. One way that the council can minimize the expense to council is, and I've done this before in other matters, the chief mover, if you will, other than the appellants themselves, of course, is the township. And the township retains a lawyer, whether that's Natalie Schreier or somebody else from Weaver Simmons. And then that person, that lawyer, appears on behalf of the township and basically punts over to me as counsel for the Agnew Lake Property Group and says, I'm prepared to defer to Mr. Roslin to make submissions on behalf of the property group. And that lawyer can then make additional submissions if I miss something or don't cover a ground that that lawyer on behalf of the township would want to be sure was before the tribunal. And so from the point of view of preparation, evidence that would go before the tribunal, there's really minimal expense that needs to be incurred by the township at this point. If it were to go to a full hearing, assuming that our motion is dismissed and so the appeals need to go forward, then yeah, there would be expense involved in that, because then you are likely into a half day or a full day process that can be expensive if the township carries the ball as opposed to Agnew Lake carrying the ball. So those are some of the considerations that I just wanted to put before you. And with that, I would pass it back to you, Mr. Mayor.
Okay, thank you. Is there any questions for any of the three gentlemen from council? Councillor Gingras.
Yes, thank you, Mr. Chair. Hello, gentlemen. I just wanted to ask Mr. Tunnick and the lawyer, it was mentioned a couple of times that there is no motion to dismiss. And if I'm not mistaken, a meeting or so ago, right here in this room, we passed a motion to dismiss the appeals. I opposed it, but I believe that motion has been, it would have passed because there was only one opposition to it. So that's first off. This is a really unfortunate situation. I did also just want to make a comment about this is our bylaws. These are our bylaws, and you could say they're under attack. However, the beginning, the conception of the bylaw was made by a private nonprofit group, the Agnew Lake Property Association. So we are the entity that has to approve what they do, but it's their document and they have developed this document on their own. So sure, it was passed into bylaw and now there's an appeal or three appeals. So the appeals are against the bylaw, but the bylaw wasn't made by the town. Let me give you an example. A few years ago, we had Conspec, a mining company that produces bulky emulsion, and they wanted to develop a facility in this community. So as a council, we gathered, we all agreed that we were in favor of the development. And so we, as a council, they, you know, looked after their property and their accesses and things like that, Conspec did, and we passed the zoning. In that particular case, that zoning was appealed. There was only one person that appealed it, not three, just one. And so, of course, we went to the, at the time, I think it was on the Ontario Municipal Board. Now it's the Ontario Land Tribunal. But at that time, at the Municipal Board, yes, we went and we defended the appeal because it was an attack on a bylaw that we had developed and were supporting. This isn't the same situation. We didn't develop this document that turned into a bylaw. And so I feel that the Agnew Lake Property Association are the developers of the bylaw. And so I feel that if it's their fight to fight, if they have appeals against this, sure, it's in the format of the township now because it was passed, but it's not our fight to fight. That's my feeling. Agnew Lake Property Association should be looking after this and taking care of it themselves. I just find it's not in our place to spend tax dollars on an appeal when we didn't even develop the document that was appealed. And that's my feeling on that. There were a couple of other things, but you know, at this point, Mr. Chair, will we be revisiting this later in the agenda?
Yeah, so we have under on the agenda under section 7. I'm trying to find it here on the agenda. Under section 7, we will be discussing, and there is a motion on the table to vote on, or there'll be two motions, whether to seek representation or not. So it's definitely, if you do have more comments, we can bring it up during minutes and reports.
Yes, and I will bring it up then, but I thank you very much for your presentations. Thank you.
there any comments from other councillors? Like I said, we are going to revisit it later in the evening when we have the motion in front of us, but any other comments or questions?
I just wonder, Mr. Chair.
Yeah.
I agree with the gentleman that we voted last meeting, I think, of dismissing it. And now you're mentioning that we have to do it again tonight.
I know we did pass a motion regarding that council had asked to have the appeals dismissed. I don't know where that motion had ended up, or whether it was officially filed, or I don't know what the process is. So maybe maybe one of the ALPG people can discuss about that. I'm not sure.
Through
Or
you,
Councillor, yeah, Councillor Gingras, go ahead.
Through you, Mr. Chair, if I could ask the CAO, what happened to that motion? That would be great.
Yeah, to you, CAO.
Thank you, Mr. Chair, through you. We did pass a motion at the last meeting, and that motion, it's in our minutes. Basically was requesting myself, the CAO, to send a letter to the OLT requesting that the appeals be dismissed. And so that letter was sent out, and it's part of report that we'll be discussing later on tonight. But as it is stated in the report, the OLT did come back with us stating that the letter was not enough to dismiss, that they would require us to present the motion to dismiss in front of the OLT when they declared it time.
Okay.
Thank you.
Okay, I think that clears that question up. Is there any other comments or questions? And like I said, we will be revisiting this this evening, so we will have time to discuss what council's thoughts are on that later on. Okay, is there any other discussion from our delegation, or I'll thank you at this time if there isn't any.
If I may, Mr. Mayor, just to respond to the councillor's concern about whose bylaw this is, I think the fact that we're not party to the process is a clear indication that this is the township's bylaw. It's not our bylaw. And I was clear, as was Mr. Roslin, that we have worked collaboratively and cooperatively over the last 5 years with the township, working together on the content of the bylaw, as well as a lot of other documents. But as I indicated, it is clearly a council decision on what they approve or not approve, because council had the prerogative to say, no, we don't approve your subdivision. No, we don't approve your zoning bylaw. They have that prerogative. So with respect, Mr. Mayor, the document is the township's document, and it's the township's document to defend. Thank you.
Okay, yeah, Councillor Gingras.
Mr. Chair, can I rebuttal?
Yep.
I just wanted to say, Mr. Tunick, like with all due respect too, if there was a very smooth collaboration between the township, the residents, and the Agnew Lake Property Association, then I think we wouldn't be sitting here today with people opposing it in the audience, the group trying to, move forward with their plan. We wouldn't be sitting here today if everything was very collaborative. And you're right, it is our bylaw. However, we didn't develop the documents that are attached to it. Thank you, Mr. Chair.
Yeah, any other comments on that? If there isn't any, we'll move on, but I don't see any hands, so I will continue, and like I said, we will discuss it later this evening. So thank you to the three gentlemen, and thanks for your insight. Okay, moving on now. to 4 public meeting of application for minor variance. A public hearing application minor variance A01-22, 36 Bell Bay Road, Township of Narren-Hyman. Councillor Gingras, can I get you to move us into a public meeting?
Yes.
And Councillor Bourrier, a second.
Yes.
Moved by Councillor Gingras, second by Councillor Bourrier. Resolved that the council meeting be temporarily adjourned at 7:30 for the purpose of a public meeting. All in favor? And that motion carries. Okay. Now this is just a motion to note the planning memorandum that was prepared by JL Richards and Associates. This is just to note it. Councillor McDonald, can I get a first? And Councillor Despatie, a second. Moved by Councillor McDonald, second by Councillor Despatie, that council notes the planning memorandum prepared by JL Richards and Associates Limited regarding the minor variance application number A01-22. All in favor? And motion carries. Okay. Is there any discussion arising from the public meeting and the application for the public variance? Is there any comments from the public or from councillors at this moment? And I will ask the CAO if she received any comments from the public in writing.
Thank you, through you, Mr. Chair. No, we did not receive any comments in writing or verbal.
Okay. Seeing that there's no comments, I will ask Councillor Bourrier if you would like to move the passing of the minor variance. And Councillor Gingras, a second.
Yes.
Moved by Councillor Bourrier, second by Councillor Gingras. Resolved that pursuant to section 53 of the Planning Act, RSO 1990, the public meeting is now officially open for comments regarding the application. Application for minor variance, Dean Lapierre, 36 Bell Bay Road, Crescent, file number 01A22. Sorry, that was just to officially open the public meeting. We have to pass it and the next motion. So that's just to officially open the public meeting. All in favor? Thank you. Carried. My mistake. Apologize for that. But barring there is no comments, I will now ask to get a motion on that to pass that. I'll ask the CAO, I'm looking at the motions here. Do we have to pass that in the public meeting, or is that passed in regular council?
Through you, Mr. Chair, the motion contained within the decision document, we would pass in public. There is and after we go back into the regular council meeting, that just states that no more notice will be given. Okay, perfect. So I'll get Councillor Despatie. Can you get a first on passing the minor variance? Yes, and Councillor McDonald, the second. Yes. Moved by Councillor Despatie, second by Councillor McDonald. Whereas having been satisfied that the notices were given in accordance with the Planning Act, and be it resolved after due consideration of the proposed bylaws, council hereby concludes there no further notice be given with respect to the proposed minor variance from the provisions of the bylaw for the following property. A, minor variance under section 45 of the Planning Act for lands described legally as 36 Bell Bay Crescent, parcel 30559, section SWS LT 23 PL M 934 Narren, Hyman, Narren and Hyman.
And council hereby grants approval for the minor variance subject to the outlined conditions in the notice of decision document. All in favor? And that motion carries.
Mr. Chair, do you mind if I just get signatures on that decision document?
Yeah, go ahead. Okay, I'll now move to close the public meeting. Councillor Gingras, can I get a first? And Councillor Bourrier, second. Okay. Moved by Councillor Gingras, second by Councillor Bourrier, that the public meeting is now officially closed at 7:36. And regular council meeting is now reconvened. All in favor? And that motion carries. Okay. Moving on to number 5, discussions arising from previous council minutes. Is there any discussions arising from those minutes? It's the regular council meeting minutes, March 14th, and the closed meeting minutes, March 14th. Okay. Yeah, Councillor McDonald.
Okay, on the economic development there, officer, how much do we gotta pay every year for that?
That'd be a question for the CAO. I'll turn it over to you.
All 3,000.
I'm sorry, I didn't hear the question.
Economic development there, that motion we had
Okay.
there. And we accepted it. I disagree, but we accepted it.
Mhm.
Was it $3,000 a year?
It was up to 3,000. I have to bring any additional expenses to council. But right now, actually, I just got a final price and it's approximately 700 a year. That is our share of the non-grant funded parts of their salary. So if they do any extra projects like, maybe they put together a website or for the area or just other things like that, we will bring it to council for approval for extra expenses. So I was being overly generous by saying 3,000, but that would be the absolute max.
Okay, so we around between 700 and.
Yeah,
3,000.
so like for this year, I'm just gonna put in the budget our normal $1,000 for economic development. That'll be for this year, and then we'll have projects that they want to work on for the next budget. So that'll be presented to council for approval within the municipal budget.
Yeah, I just got one more thing, Mr. Chair.
Yep.
Economic development, this might not be it, but building permits. The taxpayers since 2018, when we joined Espanola, and I got records here saying that, the taxpayers are paying over the expenses, over the revenue we got. In 2018, $6,000 the taxpayers paying, 4,596,000, 4,596,000, 11,960 for 2020. That's part of the economic development. They're paying to encourage people to come to Nairn and to build. Over the years up till 2018, it was neutral. The expenses and the revenue was pretty well equal. So the taxpayer wasn't paying. Now we're paying that. Now we're going to go to economic development, help us Pinello out in the area, which I can't see anything coming to there over the last few years. And we don't have no place to have much economic development because it's all mostly private land. So that's why I voted against it. Now I know we're going against Espanola and Massey and Redwood and McCarroll, but their situation might be a little different than ours. But we have the mill here, we have the power plant here, you know, T-Bell and the OCL, we got a good tax base, but you know, we got to keep the taxes down and keep our revenue up there from our reserves up. And in the last couple of years, we spent over $500,000 from the reserves. So we got to start, you know, settling down and watching our spending. And that's why I want to have a meeting with the budget before we pass it this time. Have a good look at it. Thank you, sir.
Yeah. Right. Is there any other discussions arising from previous minutes? Counselor, nope. Okay. Okay, so Counselor McDonald, can I get a move on that at first? And Counselor Despatie, a second. Moved by Counselor McDonald, second by Counselor Despatie. Resolved that the following council minutes be accepted as presented. A, regular council meeting minutes, March 14th, 2022, and B, closed session minutes, March 14th, 2022. All in favor? And that motion carries. Okay, moving on to 7 minutes and reports. This is just to, we have quite a few motions on this. I think this will be the meat and potatoes of the meeting here. So this is just to note the minutes as, or the minutes and reports as received. Councillor Bourrier, can I get a first on that? And Councillor Gingras, a second. Moved by Councillor Bourrier, second by Councillor Gingras. Resolved that the following minutes and reports 6A to L are noted as received. Township of Narren-and-Hyman, January 2022 bank reconciliation. B, Township of Narren-and-Hyman, February 2022 bank reconciliation. C, Ontario Clean Water Agency, February 2022 work order summary report. D, Township of Narren-and-Hyman Planning, Economic Development and Public Works Committee minutes, March 28th, 2022. E, Township of Narren-and-Hyman CAO report number 2022-13 regarding municipal 2022 municipal election use of corporate resource for election purpose policy. F, Township of Narren-and-Hyman CAO report number 2022-14 regarding Manitoulin Sudbury District Social Service Board appointment of the Power Dam grant revenue. G, Township of Narren-and-Hyman CAO report number 2022-15 regarding updates, option to appoint a new integrity commissioner. H, Township of Narren-and-Hyman CAO report number 2022-16 update regarding the appeals regarding zoning bylaw amendment number 2021-34. J, Township of Narren-and-Hyman CAO report number 2022-18 regarding tax registration property file number NH1808. K, Township of Narren-and-Hyman CAO report number 2022-19 regarding updated cost of resurfacing Day Street, Old Narren Road. L, Township of Narren-and-Hyman's Fire Chief report, April 5th, 2022. All in favor? That carries. And now I will open discussion on 7A or B if there's any questions on the bank reconciliation. No, I don't see any. 7C, Ontario Clean Water Agency, February 2022 work order. Okay, 7D, we do have a motion on this. This is to accept the date that we agreed on in the Public Works Committee meeting for the spring cleanup week. This motion on that, is there any comments on that? That would be from May 28th to June 1st, as discussed in that meeting. Okay, if not, I'll get Councillor Gingras. Can you move that? And Councillor Bourrier, a second.
Yes.
Moved by Councillor Gingras, second by Councillor Bourrier, whereas council notes the Township of Narren-Hyman Planning, Economic Development and Public Works Committee Resolution number 2022 PEDPW-4, and therefore be it resolved that council agrees to run a spring cleanup week in Narren-Hyman from May 28th to June 1st, 2022. All in favor? And that carries. Okay, I will move on now to 7E, Township of Narren-Hyman CEO report number 2022-13 regarding 2022 municipal election use of corporate resource for election purposes policy. Is there any comments on that? We do have a motion just to adopt it. Okay, barring no hands, I see. So Councillor Despatie, can I get a first on that? And Councillor McDonald, a second.
Yes.
Moved by Councillor Despatie, second by Councillor McDonald. Be it resolved that the CAO's report number 2022-13 be received for information. And further that council agrees to adopt the use of corporate resources for election purposes policy to establish rules and procedures regarding the use of municipal resources during the election campaign. And that the draft bylaw number 2022-07 be given all three readings on April 11th, 2022, as the policy must be established by April 30th, 2022. All in favor? And that carries. Okay, moving on to 7F, Township of Narren-Hyman CAO report 2022-14, Manitoulin Sudbury District Social Services Board appointment of Power Dam grant revenue. There is a motion on the table to consent to the change in the consent to a change in the cost appointed formula used by DSAB. So is there any comments on that? Okay, seeing there's no comments right now, I will ask Councillor Bourrier, can you move that? And Councillor Gingras, a second. Moved by Councillor Bourrier, second by Councillor Gingras. Be it resolved that the CAO's report number 2022-14 be received for information. And further that council consents to a change in cost apportionment formula used by Manitoulin Sudbury DSB from the current formula to its proposed formula shown in Table 3 of the Municipal Tax Equity Consultants Incorporated report dated December 20th, 2021, starting in the year 2023. All in favor? And that carries. Okay. Moving on, we have a few options under 7G. We discussed this last meeting, but yep.
I got a question on 7F.
Yeah.
Power Dam grant. Has that got anything to do with the grant that we're receiving now? $50,000 a year?
I'll turn.
There's quite a big article there. What are they trying to do?
I'll turn it over to the CAO. I think she has the information on that.
Thank you, and through you, Mr. Chair. So basically, each municipality that has a power dam in their community, like us, like Sauble, Spanish, and Espanola, there was a bill, I don't have the number right for me, Bill 140, that from 2001 on, power dams were not taxable. So we weren't receiving any taxes based on that. But the provision from the government of Ontario was we would receive a grant in lieu of that taxes. So the way DSAB approached our apportionment is, so they established the formula that they've been using now since in 2004. And so basically, it prevents the power dam revenue from being apportioned in a manner that reflects the individual municipality's current proportional share. So that is our assessed values in the municipality of all the properties. So the new approach that the town of Espanola approach DSAB would, it'd be ensured that the municipalities that are receiving that power dam grant, that money that we receive would share the same proportion of revenue as would an assessment of an asset or a property. So it would make it fair. So the way that they're doing it is it's not reflective of the value of the power dam. They're just taking, oh, you have this amount of money coming from this grant, here's our share that we want from you. So the way that the town of Espanola hired the tax consultants and they have lawyers now, they're in a legal battle regarding it right now. So it doesn't really change the amount of money that DSAB gets from all the area. What it does change is it reapportions the share. So Espanola and the township of Narren-Hyman would actually have a lower amount of share to give to DSAB because of the change in the values. So it's complicated and it's a little above my pay grade. That's why they have lawyers and tax consultants. But with speaking with the CAO of Espanola, we agree that this formula is fair for our communities. Whether the other towns agree, they probably won't because their share will go up. But DSAB wanted to know how we felt about it. Thank you.
I was just concerned there was quite a bit there and I didn't quite understand.
It was deep, I know.
So we're not losing, so
No.
when the government takes with one hand, they don't really always, they say they give it back and the other one, it don't work that way all the time.
Not always. No.
Okay, moving on to 7G, Township of Narren-Hyman CAO report number 2022-15. Update regarding options to appoint a new integrity commissioner. We discussed this last meeting and when the CAO and I went to the La Cloche Foothills meeting at the end of the month. Last month, we had discussed and brought up a possible shared agreement with the other La Cloche Foothills communities. And it was under the impression that the La Cloche Foothills communities were either happy with their current integrity commissioner or didn't want to make a change currently. It wasn't the right timing, but they were open to a possibility of a shared service down the road. So I do have the three options in front of us. I'll just put them on the table and then I'll open it up to comments. So the first option is that the council directs the township's La Cloche Foothill representatives to present the requested report and report back after the next La Cloche meeting, which will be held in June. That council directs staff to receive proposals for the new service and that council defers the decision until after the municipal election, which will be held in the fall. So it's really up to us what we want to do. But I do believe that La Cloche would be more into it after new councils are elected in the fall. That was just my understanding from what we got out of the meeting. And I don't think they would be totally going for it right now. It's like I said, it's bad timing for them, and some of them are fairly happy with their current integrity commissioner, and they don't use them that often. And so it's really up to us tonight. So I'll open it up for comments if there is any. I'll go Councillor Bourrier.
I really think that us as our community waiting is not our best idea, solely because we have had a very close experience with the integrity commissioner that we have now. And we all agreed that we aren't happy with the way that went. And so I don't see for us leaving it to the next council, who we don't know who it's going to be, may not be as familiar of what we have now, which none of us like. So I think that we should be at least looking into someone for our community alone for now. That's my opinion.
Yeah, Councillor Gingras.
Thank you, Mr. Chair. I think, like you mentioned, it's about timing. I absolutely agree with Councillor Burrier that we all collectively felt the same way and did want to look for a new one. However, if I'm not mistaken, and maybe through you, Mr. Chair, I can ask the CAO, if I'm not mistaken, there is a timeline regarding integrity commissioner investigations during an election year. And I don't think that they are able to investigate after X at a certain date prior to an election. If that's true, if I can find that out from the CAO, then in light of the LaCloche meeting being in June, that's far too close to an election, and I would support waiting until after the election, provided I know that the integrity commissioner cannot investigate after a certain day. If I could.
Yeah,
through you,
I'll turn it over to the CEO. I believe that that there is no investigations allowed after nominations open, but I may be wrong.
Thank you, Mr. Chair. Yes, you're correct. From the beginning of the nomination period to the end of the year, an integrity commissioner cannot start a new inquiry or investigation.
And that nomination date usually is in early May, I believe.
You're correct. Yes, May 2nd.
Okay, Mr. Chair, in light of the integrity commissioner not being able to do investigations from May 2nd, which is like in a couple of weeks, until the end of the year, I fully support waiting until after the next municipal election. Thank you.
Councillor McDonald.
Yes, I don't agree with Gingras. I think we should start immediately, and that'll give us the gap to get a new one in place to replace the old one. And I think we should start right now, same as Kathy feels. And I'd like to hear what he has to say, but I would recommend that we start now.
Okay, I think Councillor Bourrier had her hand up.
No, it's good.
Okay,
Information, I appreciate that. Thank you.
okay.
I'll make a comment on that.
Yeah, go ahead.
Having newly been appointed, I quickly realized that it takes a long time to get anything done. I agree with Rod. We should start looking right now to be ready for the new council. I agree with that.
Yes.
Okay. Is there any other comments? Yeah, Councillor Gingras.
Thank you, Mr. Chair. In light of my colleagues' conversations just now, comments, I would support looking into it right now also.
Okay, so it seems like option number 2 is council's prerogative, and I was after hearing some comments, I would support that as well. Regardless, we can receive proposals and see what happens and go from there. So Councillor McDonald, can I get a first on that?
Yes.
And Councillor Despatie, a second?
Yes.
Moved by Councillor McDonald, second by Councillor Despatie. Be it resolved that the CAO's report number 2022-15 be received for information. And further, that council directs staff to receive proposals for integrity commissioner services. All in favor? And myself as a yes, so that carries. Okay, now go to 7H, Township of Narren-Hyman CO Report number 2022-16 regarding reopening of the Narren Community Center. There's two options, yes or no, is what our options are. So is there any comments on that? I am going to voice my opinion and say yes. It's time we open the hall back up for rentals and events, and continue on the path of being at the mercy of the provincial government that controls what is open and what is not open through this pandemic. So that's my thoughts, but if there's any other thoughts.
I agree with you, Mr. Chairman.
I think we're all in agreement. Okay, so Councillor Gingras, can I get a first on that? And Councillor Bourrier, second. Moved by Councillor Gingras, second by Councillor Bourrier. Be it resolved that the CAO's report number 2022-16 be received for information. And further, that council directs the Narren Community Center to be reopened for events and rentals. All in favor? And myself as a yes, so that carries. Okay. We'll now move on to 7I, Township of Narren-Hyman CO Report number 2022-17. Update regarding appeals regarding zoning bylaw amendment. Once again, we have two options in front of us, whether to formally represent the municipality at the OLT hearing or to not have any formal representation. And we heard the presentation from ALPG this evening, so I will open it up for comments on that now.
Just a little bit confused yet. What do you mean that you say that again, the two things?
Yeah, so option one is that council will allocate resources and have our municipal planner and legal counsel formally represent the municipality at the hearing. And the second one is that the municipality will have no formal representation. So it's whether we have our legal counsel and our municipal planners go to the hearing and try and defend our bylaw by putting in that notice, the motion to dismiss. And if that is not granted, that could be, we don't know how long, like the ALPG said, that could be a day, it could be a half day of legal fees. And we did hear that the ALPG is going to put a motion in to be a party to the case. So I'd like to hear council's thoughts on whether we should go for it or not.
I think we should go with the lawyer and our developer. They're number one, what you said there. Number one is we have our lawyer, not the representatives.
Yeah, correct.
I think we should go that route. But I don't, that's the way I feel. But the rest
I think Mr. Shaw had on it.
Yeah, I think, there's Mr. Shomon has his hand up. I can see him there. So go ahead.
I think we had offered option three, and the option three is that we would supplement the costing with the township for that process, for that motion to go through. So, we'd be working collectively together to be able to get it through. Failing that, then it means that we would have to go on our own. We're fighting something else that's really not totally part of our duties, but prefer to work with the township, okay, in order to get through the process. We again subsidize the sharing of the costs.
Yeah, I think Councillor Despatie, you have your hand up.
I've got a question. This all happened a little bit before I came on the scene. These three appellants, they're part of your association. Two of them are, but you're offering to pay some of our costs to fight against them?
We pay for it. They're paying for it. Paying for their lawyer and our lawyer.
Because there's 50 other people that.
The corporation
No, there's not
consists
50
of
other people.
50
There's only 40 of you that agree.
There's 52 people in our.
In the
organization,
association.
Okay. This was voted 99%.
No.
To what
No, no.
we are.
There was 100% vote on another, at the beginning, and it did not vote with these guys. What we're after is just equal access for our places out to a public road. We put down pamphlets forward here with all of what these guys have been putting forward and trying to block our accesses. That's all we're asking for is there's 6 driveways that they're not allowing access to out to the public roads. And they're landlocking us and they just.
There's no
won't,
blocking
give it.
of access.
There's no blocking.
Everybody has access to their property. There is no blocking. People
You gotta put that
that
in writing,
are,
because your person that you came door to door with said there would be. If you didn't pay to get into it, you were not. One thing I'd like to mention, yes, they have a group that they have gotten together and they have their votes, but they never consulted the rest of us that live up there, that have our own private property, and it will be affected by what they're doing. And it does come down to all as to access, because I had their representative come and talk to us and say that we have water access only. So for the past 40-some years, where that place has been up there, that we've been going to, now we're being told, we either pay them, or we take a boat to get you a camp.
the issue here is we forwarded an amendment to Gary stating that they had private access through Lakewood Drive. There was no issues with that having restrictions to their access. That is not an issue with the Aggie Lake property group. That's never been an issue and will never be an issue. It's documented into an addendum to the amendment that we've done already. So it's legal. It's a legal document. We cannot stop them. Whether they think we can or not, we can't. So that's a non-issue. I've met with them all personally. I've discussed it with a lot of people over there. I've had one individual that just refuses to accept anything that would be said or anything that would be put on paper. And there's nothing else I can do. That's as far as.
Okay, Mr. Mayor, Mr. Mayor.
Okay, yeah,
if I may,
Councilor Despatie, go ahead.
So there is documentation that they have access.
Yes.
And can we find this and give this to these people so that they can drop their appeal? Then they'll have it in writing.
Excuse
They'll
me,
have it in
Mr.
writing.
Pache. All we want is our driveway. There's 72 extra acres that we all paid for, all 52 of us, all paid our equal share of money. And they're blocking us from our public road, the Golden Road. There's 5 of us there. Well, we only 3 of us made appeals. We're not gonna pay $600 each for each appeal. There's a whole list of people we can bring in that also have a problem with this problem that they just don't agree with.
And they don't want to work with us.
They don't want to work with us.
They've created utility lots that do not allow, like, they're gonna be building buildings in front of us to have.
Well, I'd like to see that document that gives them legal access.
I think you've got it.
And that will end the discussion altogether.
Well, it doesn't. You'd have to look at the maps, Mr. Pache, and the maps will clearly show how they're trying to landlock us and block us in the Aggie Lake Property Group and other people on Crown Land.
Would you not be satisfied if we could get you a
No, I would
document?
not, sir.
You wouldn't?
No, I would
All
not. I
right, well,
would
then,
be
I
satisfied
think we
with
should get
access to
together.
Bullock Road.
I think we should get together with the Aggie Lake group and fight their appeal.
So you're saying, Mr. Pache, you're agreeing with these members of the community, and you would rather take your lawyer and fight against the rest of us?
It
That pay taxes.
appears to me, sir, that you're not willing to accept a document in writing that gives you access to your property, which is what you're trying to appeal in the first place.
Oh, Mr. Pache, you have to read the whole documents first.
before you can come to a quick conclusion that you're coming to right here.
What he's referring to-
Do some examination on the
What
whole
he's
thing.
referring to
Okay.
is not the appeal process.
Okay.
It's not part.
That's what Mr. Connick had said.
I get order. I'm gonna call it back because at the council table right now is whether the township will have representation. Councilors know that what the issue is and what the bylaw that was passed in front of us tonight. We have whether council will be legally represented at the hearing. Is there any comments? Councillor Shingra.
Yes, Mr. Chair, I already spoke to this earlier, and I just feel that the Agnew Lake Property Association should defend their own document. We didn't develop that document, and I don't believe the taxpayers of Nairn Center should be on the hook to pay for planners and lawyers on behalf of the Agnew Lake Property Association, which would also be going against many of our residents. Therefore, I support not allocating funds and resources to the Ontario Land Tribunal hearing. Thank you.
Councillor Boyer.
I feel that if this bylaw is well-grounded and well-founded, there should be no need for us to spend that amount of money, up to $28,000 to $30,000, to defend a bylaw. If the bylaw is good, there should be no issues with it.
Yeah, I believe the gentleman in the front row of the public has his hand up.
Just like to sort of reiterate that ALPG is not a separate entity. ALPG is a whole bunch of us, and we are all taxpayers. And I think we're a very substantial amount of taxpayers. It just, when Councillor Shingra talks, she talks like we're this group out there, and the taxpayers shouldn't be charged with defending a bylaw when we're taxpayers. All the rest of us that have
Excuse
gone
me,
through this
Mr. Chair,
process
I'd
for
like
over
to
6
rebut
Order.
that audience, but
And
excuse
we
me,
voted
I
on all that
also,
stuff.
Order.
taxpayers like you, I represent these taxpayers over here also. They are also taxpayers
when you
in the
talk-
same community.
When you talk like it's us against the taxpayers.
Well, it is
we
right
are
now.
the
3 of them
taxpayers.
have appealed the document you made. And so, yes, I'm the voice for the people
I just want
over
to say one
there
thing,
that
okay?
oppose it.
I got scolded by her at the last meeting when I was here in November of the 8th. And I've got that on file. And I'm not going to stand here today and get scolded by that counselor.
Mr. Chair, I'm entitled to my opinion. I do-
Council,
And I will speak on behalf of whichever residents I choose to, and that is my job, to be the voice of the people that don't clearly have a voice here today. Thank you, Mr. Chair.
Excuse me, Mr. Chair, wasn't he, my husband Ed, given the floor?
That-
You said-
that's who I was looking at. My apologies. Go ahead if you have a comment. Yeah.
Ivan says he was approached by the people that were complaining, and we were complaining, nothing on the survey, nothing on the roads, nothing whatsoever. We were approached in this situation we're in.
This is an easy.
We're
fix.
rehashing something from 6 years back. It's
So
the
fix it.
same story, the same people, and it's the same, we're going to hear the same thing.
You can fix it easy.
And it has nothing to do with the bylaw.
Get rid of those utility blocks that are blocking. That's all it is. So easy to fix.
Okay, I will, I'll open it to council comments now, and I feel like we've heard enough from the public. And we'll open up council comments. Councillor Despatie.
Well, contrary to Councillor Shangra, we approve this bylaw, and it's up to us, at least in whole or in part, to defend the bylaw. It's simple as that. We did it, not me personally, but our past council approved that bylaw. We have to defend it. It's as simple as that.
Councillor McDonald.
Agreed. It seemed to me that, you know, like, we represent Aaron and we represent Hyman. Whether we spend a little bit of money, labor, lawyer fees here, we're helping them, we're helping taxpayers on there on Hyman. I know Councilor Jinger said that we should be paying for their help with them. They're there in Hyman. We're one company, one town now.
Yeah.
And it sounds like the group up there, the two groups up there, they can't get along amongst each other, so they're coming to council
To try and do something.
to solve their problem, and that's the only way we can do is get a lawyer and defend our bylaw.
Yeah.
We have to do it.
Councillor Gingras.
One more comment, Mr. Chair, just to rebuttal my colleagues, is the group, the Agnew Lake Property Association, and we saw it tonight, they have a lawyer and they have a planner. So they will be represented by a lawyer and a planner. I just don't think the people of Narren should have to pay for another lawyer, which is ours, and another planner to be at the table. I think we're doubling up on money that we shouldn't be spending. One lawyer and one planner, I feel, is sufficient. And they're very professional, and I'm sure they're experienced and know what they're doing. We saw them both tonight, the planner and the lawyer. And I think that is sufficient. If they want to go to the Ontario Tribunal, they've got a lawyer. It's not like they don't have a lawyer and they need the town lawyer, or they don't have a planner and they need a town planner. They do have that. And again, I'm just representing the folks out there, not only the ones that appealed or that are within the Agnew Lake Property Group, but even the people that aren't, that are out there with private homes. Like some of the road changes will affect them. And we have to, you're right, speak on behalf of everybody, but we're spending money here. And if there was no lawyer or no planner, sure, we could possibly send our lawyer and planner, but they have one. Why should we double up and spend extra money out of our coffers for the people of Narren to support a lawyer and a planner, for a second lawyer and a second planner for the hearing? And I just don't think that it's efficient whatsoever. Thank you, Mr. Chair. Sorry, one more comment. I just had one more comment. I thought of it, sorry. When this original document came to council, it would have been July 2020. I was kind of not in the loop of council. I had personal issues. Anyway, at that time, that would have been the original document that you should appeal. That's the big draft survey that they had done, that they handed to council. At that time, when that document was approved by council, there was an appeal. The appeal was tried to be put forward. The people handed their check to the town, possibly didn't fill out the paperwork right, or something was askew with the appeal, and they received their check back from the township for the appeal. So it's not like they've never, ever tried to appeal this. They have. And I think we just need to speak on behalf of, I'm speaking on behalf of those people. And thank you, Mr. Chair, for the time. I still won't support any more money going to the hearing. Thank you.
Councillor McDonald.
This is our bylaw, township bylaw, and we should defend it. We shouldn't have to rely on the groups to do it. We have to do our own bylaw. And we got a legal system, we have to go through it.
I have one question. If you're gonna have a lawyer to defend Agnew Lake Property Group, you're gonna hire a lawyer to defend your other people here?
We're gonna have a lawyer to defend our bylaw.
Defending the bylaw, yeah.
Okay.
We have a letter to submit to the council that we prepared prior.
That's up to the mayor chair.
Oh,
Yeah, usually we take them before the meeting, but if you would like to read it right now, that is fine. But usually we try to accept them a couple business days before the meeting. But if you would just like to read it out loud, that would be fine.
sorry, we just found out about this meeting today. your honorable mayor and councillors, we, Ed and Pat Wyris, feel it is inconceivable that our appeal is again being contested by the ALPG group lawyer, along with Glenn Cunnick, the ALPG planner, and also, I don't know if he is still the township planner or still involved with the township. We are Lot 8, Map 2, the east side. Our boundary lines are with undeveloped Lot 7, Gord Goodwin, former president and ALPG director, who hired Glenn Tunick and surveyor Dave Dorland while as president, along with Lot 9, Karen Hasty, also former ALPG board director, and our other boundary. We're in the middle of these two. We were never listened to. We were never advised or acknowledged or had any input. There has been a conflict of interest from the start with our historical survey page being moved without our knowledge, nor consent, nor discussion, under the disguise of what is best for them, not for us. We have lost water frontage, historical roads, and I'm talking historical roads that my dad built and Ed and I maintained for over 60 years. And we were built, when we weren't there without our knowledge, a cow trail. And they took down full-grown trees, clear brush on open land, and said, and Hasty and former president Gord Goodwin would put up fences and blocking us, which was not supposed to be done. It was clearly stated by our former lawyer for the group, Murray Scott, who said there's to be no changes, no new construction, no new buildings, no new roads until the title of the parcel is transferred into members' names. And Mr. Shomont himself, as president, sent that letter out to all the ALPG members. And our next door neighbor, when she built that fence, Ivan, our president, went over, but he said, what can I do? She already had it up or was already building it. Now, this last moment, ill informing us, we're 75-year-old seniors purposely with proper time to prepare and get a legal advice in advance for this, whatever delegation. And this is causing them stress, anxiety, health problems, and it's intimidation and harassment. We thank you in advance for your consideration. And this letter is without prejudice. It's just that we have been sandwiched. Nothing has been informed to us. They just do what they want. They move the lines, they take the roads, they do whatever they want without our knowledge or consent. Please, please reconsider approving. Lines are lines, but it doesn't tell the whole story of what went on. If you see the pictures.
Okay, thank you for your letter.
Thank you very much.
There's someone in the audience.
Can I rebut that letter, or?
Yeah, sorry, I believe the gentleman beside her has his hand up for a comment.
I want to speak to you, and I understand you're a new person on the board, and your comments cannot feel the pain of 6 years my wife and I have been dealing with.
Well, I sympathize with your pain, but my duty as a counselor is to represent what we do. And if a previous council deemed the engineers that developed and this subdivision, they must have been competent and did a good job.
We didn't have all of that.
No conference.
What about
No say.
conflict of interest though? Glenn Murray worked for the township, he worked for ALPG.
I think the best way is to bring it to the appeals.
Well,
which-
that's what we want to do.
And
so
we're
here's
going
the
to
vote.
defend our bylaw and
We
we'll
want
see what
the
happens.
appeal.
We
We
Okay.
want-
Yeah, we want the appeal.
I think it's time. I think it's time. The appeals are in. This is simply if the township will have legal representation at that appeal or not. It seems that that ALPG is willing to pay for some of the legal costs. It's very difficult for me. I have to take the side, I believe, of Councillor Gingras, because I don't think that we didn't develop this bylaw. It was handed to us and we passed it. This is not, yes, it is our bylaw now, but to echo what Councillor Bourrier said, if the bylaw is good enough, it will stand. It will be enough representation. That's my thoughts right now, but we can put it to a vote and see what happens. But I think it's time to go through the motion if there's any other comments.
I think if we don't take legal, Mr. Mayor, if I may. If
Yeah.
we don't,
Go ahead.
we don't take legal representation for our actions, then it's, I don't understand how a municipality can not take legal representation for their own actions. Whether this bylaw is going to stand on its merits, we still have to represent ourselves at this appeal. It's fundamental. You don't go to a murder trial without a lawyer. Only a fool represents himself. Anyway, that's my comment.
I mean, the way I look at it now, if the ALPG applies to become a party to this case, then it's on them to defend this if that's what they so wish to do. They're going to apply to be a party. If the tribunal grants them that they are a party, they're the ones that have the lawyer and have the planner and have the funds to represent that. And it seems like it's a bunch of things between ALPG that we weren't privy to or we didn't decide. You know, at the end of the day, yes, we decided the bylaw, but that was the bylaw that was given to us. Okay.
Let's vote.
All right. This is for the vote to have no formal representation. So I guess Councillor Bourrier, will you move that?
Yes.
Councillor Gingras, a second.
Yes.
Mr. Chair, I'm requesting a recorded vote.
Okay, requested from recorded vote from Councillor McDonald. I'm circling your name. So we'll go through Councillor Bourrier, for or against. Oh, sorry, let me read the motion, my bad. Moved by Councillor Bourrier, second by Councillor Gingras. Be it resolved that the CAO's report number 2022-17 be received for information. And that council directs that the municipality shall have no formal representation at the OLT hearing regarding the appeals against the zoning bylaw amendment number 2021-34. Councillor Bourrier, in favor or against?
Favor.
Councillor Gingras, in favor or against?
Favor.
Councillor McDonald, in favor or against? Against. Councillor Despatie, in favor or against?
Thanks.
And myself is for, so that is carried. Okay. Moving on to 7I, Township of 7J, Township of Narrenheim and CAO report number 2022, number 18 regarding tax registration property file NH1808. I'll just wait a moment. I believe there's a bunch of people leaving, so.
Thank you.
Thank you for coming. Warner. Thank you, Mr. Showman.
Okay, sorry.
Okay. Are we good to go?
That's all everybody was waiting for.
That's how to clear a room, I guess. All right, 7J, Township of Narrenheim and CO report number 2022-18 regarding tax registration property file NH1808. Is there any comments on that? That was to cancel the tax arrears certificate. Councillor Gingras?
Yes, Mr. Chair, I support canceling the arrears. I was just wondering if we cancel those arrears, does that now make the property more eligible to be sold and developed privately? Or if someone wanted to purchase that property now, would they still have to pay the liens and things like that? And you can't eliminate?
Yeah, I believe it would definitely make it easier for someone to purchase that property. On our side of things, I think this is the best we can do after having some discussions with the CAO on this. I think at this moment in time, this is the best thing that council can do if we want to move forward on someone possibly acquiring that land and developing it. But if the CEO has any more comments, I would turn it over to her.
Yes, I do, through you, Mr. Chair. I just want to make a clarification that if we cancel the tax arrear certificate on that property, we're not canceling the back taxes owed.
Oh.
It's just the removal of our lien on title of that property. So the way it's sitting now is there's a tax certificate on title. That property can't be sold unless we're paid. So we've reached the time limit where we either have to vest the municipal or vest the property and take on all its liabilities. We won't obviously be getting any of our back taxes back. And then we would have to negotiate with the federal and provincial government to remove their extremely substantial liens. Then if we in turn sold it, we would be liable if there was any contamination. So at this point, it's my recommendation that we cancel it. And it doesn't stop us from putting a tax arrear certificate again in the future. And potentially we'll have a plan in place to try to get around the many problems with this property. I have seen other municipalities, once the new tax certificate goes back on it, they have 2 years that they can actually go in and do environmental testing, even though they don't own it. So that is a possibility in the future that we can re-put a new tax certificate on it, go in, do some testing, look at how much it's going to cost to remediate it, and then make a decision. But at this point, we either have to A, cancel it, or B, take it over completely. So it's my recommendation that we remove our lien on it.
Okay, is there any comments on that?
Yes, I support the CAO's recommendation, Mr. Thank you.
You as well.
For sure.
Okay, let's put it to a vote then. So Councillor Despatie, first on that. Councillor McDonald, a second. Moved by Councillor Despatie, second by Councillor McDonald. Be it resolved that the CAO's report number 2022-18 be received for information, and that council resolves to cancel the tax arrears certificate on the subject property described as file number NH 1808. All in favor? And that motion carries. Okay. We will now move on to 7K Township of Narrenheim and CEO report number 2022-18 regarding updated costing, resurfacing of Day Street, Old Narren Road. Is there any comments on this? The motion I have in front of me reads that council accepts the preliminary cost estimate for resurfacing Old Narren Road for the allotment of the 2022 NORDS funding, and that council directs staff to include this capital project in the municipal budget, and that staff is authorized to proceed with the planning stage of this project. So that's what I have in front of me. If there's any comments on that, I know we talked about it a bit last meeting.
Excuse me, Mr. Chair, I'm so sorry. I don't mean to interrupt, but I do have an update on this project.
Okay, yeah, go ahead.
Thank you. I just received an update from the NORDS funding. So in my report at the last meeting, I discussed that we had received an allocation of 60,000 and change for this type of project. I just received word that that was our 2021 allocation. So we're actually getting that amount again this year. So it'll add up to, you know, almost like 100,000. So it will more than cover this project. So it is my recommendation that we go ahead.
Excellent.
Awesome, perfect. Is there any other comments on that then? Can put her to a vote. Okay, Councillor Gingras first. Councillor Bourrier second. Moved by Councillor Gingras, second by Councillor Bourrier. Be it resolved that the CAO's report number 2020-19 be received for information, and that council accepts the updated preliminary cost estimate for resurfacing Day Street, Old Narren Road, from the intersection of Minto to the end of the municipally owned road near the entrance to the Interfor Timber Mill of the allotment of the 2022 NORS funding. And further, that council directs staff to include this capital project in the 2022 municipal budget, and staff is authorized to proceed with the planning stage of this project. All in favor? Motion carries.
Belinda.
Okay, moving on now to 8 correspondences. This is just to note the correspondences as being received. So Councillor McDonald the first. And Councillor Despatie a second.
Yes.
Moved by Councillor McDonald, second by Councillor Despatie. Resolved that correspondences 7A be noted as received. That should say 8A. 8A be noted as received. All in favor? And motion carries. Is there any comments on 8A, Lauren Mick, regarding Citizens Alert app, Narrenheim quote, March 23rd, 2022. We received a presentation from Mr. Mick last meeting, and he is graciously giving us a 6-month free trial. And then the costing is in the report that was given to us. So this motion is to go ahead with the free trial, and then staff would prepare a report at the end of the trial to see if it's beneficial or not for the community. Is there any comments on that? Councillor Bourrier.
I love this idea, and I think the 6-month free trial is perfect. If we don't use it, then, you know, we don't need to take it. And I believe that between the fire chief and our recreation department, if they have the ability to use that system, I think nothing but good things can come from this, and it's free. So,
Okay. All right, so Councillor Bourrier, can I get a first on that? And Councillor Gingra, a second?
Yes.
Moved by Councillor Bourrier, second by Councillor Gingra, whereas correspondence has been received from Lauren Mick regarding the quote for the Citizens Alert digital communication platform. Be it resolved that council agrees to a 6-month free trial, and further that council directs staff to prepare a report discussing the achievements of the communication platform near the end of the trial period. All in favor? Motion carries. Okay, moving on to motions 9A, Town of Georgina regarding federal government sanctions imposed on Russia, March 31st, 2022. This is just to support the motion that was sent to us by the Township of Georgina. So is there any comments on that? If not, I'll get a first. Councillor Despatie, can I get a first? And Councillor McDonald, a second. Moved by Councillor Despatie, second by Councillor McDonald, that the Corporation of the Township of Nairn and Hyman endorses and supports the resolution of the Town of Georgina denouncing Russia's unjustifiable war against the Ukraine, and that Township of Nairn and Hyman supports the sanctions which the federal government of Canada has thus far imposed on Russia, and further that a copy of this motion be sent to the Town of Georgina. All in favor? Myself is a yes, and that carries. Okay, moving on to 10A, bylaw number 2022-07, being a bylaw of the Corporation of the Township of Nairn and Hyman to adopt a policy for the use of corporate resources for election purposes. Councillor Gingra first, and Councillor Bourrier second. Moved by Councillor Gingra, second by Councillor Bourrier, that being a bylaw of the Corporation of the Township of Nairn and Hyman to adopt a policy for the use of corporate resources for election purposes be read a first, second, and third time, and its number and finally passed in open council, and its number shall be 2022-7. All in favor? Motion carries. Okay, moving on. This is to 11A and B to note the for information items only as received. Councillor McDonald the first, and Councillor Despatie a second. Moved by Councillor McDonald, second by Councillor Despatie. Resolved that the for information items only items 11A and B be noted as received. All in favor? And motion carries. Okay, moving on, I will turn the floor over to Councillor Despatie under 12A, discussions regarding the purchase and installation of a columbarium in the Nairn Cemetery.
Yes, well, thank you very much, Mr. Mayor. I think I provided you with, or Belinda provided you with the estimates. So basically, a lot of municipalities have columbariums. It's a choice that we offer our taxpayers that don't want to be buried. I spoke personally with the 4 individuals who gave me the estimates. I was very impressed with the gentleman in Sprague, Elliott Lake Monument, and he happens to be the least expensive. The only comment I would say with Sudbury Memorial Works is all Canadian rock, all manufactured in Canada. Whereas the other 3, They have a mix of Canadian rocks manufactured in India or China and returned back. So Memorial Works is quite expensive because it's our Canadian manpower that's doing it. So this is a choice. Maybe I should have a pecuniary interest, but this is what I want to use for my burial. Not that it's pending or anything. I believe that other taxpayers may be interested in this. They certainly are in many other communities. There's costings. We can recuperate all the money that we spend to get it installed. So I'm just throwing that out as an idea for you people.
Councillor Boyer.
I just have one question. It's honestly, like, where would we put that? I'm just curious because there's two graveyard cemeteries. I think one is Catholic and the other one is United. Is it United or?
Is Anglican.
Anglican.
Yeah.
And Catholic, the Catholic.
Well,
is
And the
back
township
here.
has one down further past the night.
Mhm.
Yeah,
The one on the hill is
Yeah.
Marin?
it's Marin. So,
Oh. look
yeah,
where,
I would
uh,
suggest
like,
the
Where
municipal.
Joey Austin is buried?
Not
Yes.
The municipal one. Which is
Okay.
the proper.
Okay, I got it now. Thank you.
Now, first, I don't agree with it. Not that you know, you buy a plot, and now if you get cremation, you can put 6 in there. And I'm not a religious man, but I do believe, that once you pass away, it says in the Bible that do not make a fuss on it for us. Do not fuss over the dead. It says that right in the Bible. I don't know. My dad used to be religious and so why have all this cost? And that one building there was $30,000.
Yeah, like I said, the one out of Elliott Lake Monument, it's very, very reasonable. And the cost to our taxpayers to get a slot would be very comparable, if not less than a whole coffin site. And it's not a cost. It's an expenditure, but we can recoup every dollar that we spend on it. It's to give the taxpayer an option.
Yeah. Well, we're here to do the right thing for the taxpayers. And I like to hear from them personally before I make a decision on it. And personally myself, I say no, but for years we had graveyards. And now the upkeep of those buildings you were talking about, you know, you gotta keep them updated.
No, it's granite. You don't update granite. You don't upkeep granite. Granite weathers all day long. And the only upkeep is to put the date and the name of the person that dies and is put in a particular slot. And that's the cost to the person that buys. It's not a cost to the municipality.
Yeah. No, this is the first time I heard about it, so I'm not gonna jump on it.
You don't have to mow the lawn around it either.
What is that moving on?
No, but I mean, like, there's no lawn to mow at the footstep of that.
Oh,
It's all concrete and granite.
Councillor Janka?
Hey, Mr. Chair, I like the idea because it gives folks like residents an option. And, you know, if you're alive now, we erect this and then people see it, they might be like, oh, you know, when I pass away to their family, I want to be in there. And so the more options, the better. And I do agree with it. I think it's a little pricier. I was surprised how much it cost, but I guess in the grand scheme of things being granite and things like that, it's not that expensive. But I think an item like that, we would, for one, discuss again at budget time. I don't know if I'd be ready to approve it like tonight right now.
No.
But I mean, I think we could maybe bring it to budget, and also possibly our very efficient administration could find grant money. And so if there was grant money put into this, I'd absolutely support it if we didn't have to put a cent in, and that could be out there. I don't know. Sometimes there is grant money for these things, but I do support the idea, absolutely. And thank you for your time on this, Councillor DePatie.
Thank you. One final note, the Elliott Lake one, Elliott Lake Monument estimate is not even $8,000.
Oh, is it? See, that's not in here.
Yeah, it is.
Is
Yeah.
it? Where is it?
Yeah.
Yeah, it's not even $8,000.
Oh, see, 8,000 is not bad. I was looking at the $19,000 one.
That's subdivision.
Then the other one was 30. That was.
Yeah, well, I was explained why there's such a discrepancy in price, and price gouging is very much a factor.
Oh,
So, and then there would be a couple $1,000 cost, because we got to put this on a 5-foot deep base.
right.
But we have the technology, I think it can be done
Yes. we do.
inexpensively, and you'd have 2 slots sold
700,
probably before it's installed.
right.
But I would buy 2 right away. A little bit of advertising on the app. All gone.
Right?
Okay, yeah, I agree with the idea and, oh, yeah, go ahead, Counselor.
I'm the only ones against this, but now I lost my train of thought when I had yelled. But I don't think we should move forward for this budget. I think the taxpayers of this community have the right to know what's going on in this council, what we're spending this money on, and they're up to the township to send flyers out or advertise or whatever we have to do to get the taxpayers' opinion, because we go ahead and many times and vote on something and then we get blasted because of the taxpayers just agree with us. And this is their town, not our town. We work for them. So let's give them a chance. Ed or Guy, and see what they got their opinion of it, because this is the first time I heard of it. To tell you the truth.
You gotta get with the times. Rob.
Oh, he's the last mayor told me the same thing. When I was that, older and wiser, you don't realize that? Older and wiser.
I'll have to disagree with you on that.
Okay, yeah, we don't, obviously, we're not making a decision tonight on it, so we can, I have a blank motion here. It just says council has reviewed the other business item shared by Councillor DePatie regarding the purchase and installation of a columbarium in Nairn Cemetery, and be it resolved that council directs, can we say directs conversation to be had at a later date, or yeah, Councillor?
If I may interject, Mr. Mayor, perhaps in that motion, I would prefer if the first use of our new free app, that we would advise our citizens that we're considering this, and please contact us to show interest if
Here, I agree with that. I agree with that.
Yeah, but don't forget now, Mr. Chair, the taxpayers, many of them don't have the apps, phones to put apps in, and are they gonna put the apps in, or do we have to put it in their
We
phone?
could do a flyer.
we can do a flyer, but we can start with this
Yeah.
app.
We can do a flyer, like, yeah. We can do lots of things to get input.
I am writing up the motion right now, and I'll see if it works here.
We don't need a referendum on the ballot. or anything.
We already passed that read anyways.
Okay, so I have be it resolved, the council directs that conversation to be had once the township has received input from the taxpayers via the Citizens Alert app and or flyer. How does that sound?
Very good.
Sounds great.
Good. Okay, Councillor Despatie, would you like to move that then?
Certainly would.
And Councillor Gingras, a second? Moved by Councillor Despatie, second by Councillor Gingras, whereas council has reviewed the other business item shared by Councillor Despatie regarding the purchase and installation of a columbarium in Nairn Cemetery. And be it resolved, the council directs that conversation to be had once the township has received input from the taxpayers via the Citizens Alert app and or flyer. All in favor? Motion carries. Okay, and two more to go, folks. We have our confirmatory bylaw. Councilor McDonald, the first. And Councilor Despatie, a second. Moved by Councilor McDonald, second by Councilor Despatie, that being a bylaw to confirm the proceedings of the Council of the Corporation of the Township of Nairn Hyman be read a first, second, and third time and finally passed in open council, and its number shall be 2022-8. All in favor? Carried. And last one, Councillor Bourrier, a first. Councillor Gingras, a second. Moved by Councillor Bourrier, second by Councillor Gingras, that the meeting of April 11th do now adjourn at 8:56 p.m. and to meet again on the 9th day of May 2022 or at the call of the mayor. All in favor? That's carried. And I'll discuss with Belinda tomorrow about a possible day for a budget meeting, depending on when our audit is ready to go. But I'll call you tomorrow, Belinda.
Thank you, Mr. Chair. Great meeting.
Thanks, everyone. Have a good evening.